I'm Judge David Leinefeld. I'm a retired judge sitting by assignment of the Ohio Supreme Court. And this is the matter of the State of Ohio versus Philip Cook. It's case number 24 CRB 781. You're Mr. Cook, correct?
I am.
Mr. Cook, I don't know if you're represented or not by Attorney Warren in Morford Jr., but good morning, Mr. Morford. You are present here, and it's your understanding that you are representing Mr. Cook, is that correct?
That's correct, Judge. I've never been relieved by this court of my duties to Mr. Cook, although I'm going to ask you to do that when the time is right.
All right. And representing the state is Special Prosecutor Ryan Q. Ashworth. Good morning, Mr. Ashworth.
Good morning, sir. Thank you.
And let me clear up a few things first. On October the 28th, Mr. Ashworth, you filed basically a nolle prosequi with respect to count 1 of the complaint. That is the theft charge. Is that correct?
Yes, sir. I did.
And your basis for doing that is?
After review and preparation for this hearing and looking at the current status of the law, I did not feel like it was appropriate to bring that charge under a variety of new cases that has come out. I didn't feel like it was the appropriate charge for the facts as I reviewed them after interviewing the witnesses and preparing for what I believe to be the trial. I believe that the charge should have reflected a disorderly conduct, and so the second motion I filed on the 29th or the 28th, I believe, was a motion to amend count 2 from the trespass charge, which is an M4, down to the disorderly conduct charge, which is a minor misdemeanor.
Very well. The court has granted your motion to dismiss the first count in this matter. Furthermore, the court has granted your motion to amend count 2 from the charge of criminal trespass to one of disorderly conduct. I believe that's under section 2917.11A1 of the revised code, a minor misdemeanor. In addition, you filed a position statement, Mr. Ashworth, on October the 29th of this year, whereby you indicated that it appeared from filings made by Mr. Cook that he's engaging in hybrid representation, which is prohibited in the state of Ohio. Is that correct?
Yes, Your Honor, and the 4th District just ruled on this at the end of May of this year in State versus Lucas, cited in my position statement. Anything that was done by the defendant as a pro se or in the ostensibly as a pro se defendant, when he has counsel of record that has not signed off on the motion, whether he calls it hybrid representation or not, it is effectively by the actions that he had taken hybrid representation by the case law, and therefore invalid, and I asked the court to void all of those filings ab initio, as though they didn't exist and were never had.
The court finds that position well taken. Indeed, it follows the Ohio Supreme Court's ruling in State v. Martin, which is 103 Ohio State 3rd 385. So the fact is, any of those filings, and I've made an order, I've entered an order to that effect.
Judge, may I be heard on that point?
No, because you were represented by counsel at that point, Mr. Cook, and the fact is, you're not permitted to have representation and represent yourself. We call that pro se representation. That is essentially a hybrid representation, and that is not permitted. So Based on that, the court did enter an order that all your pro se filings, which are not signed by Mr. Morford, or which do not seek to confirm a knowing, intelligent, voluntary waiver of counsel in open court, are null and void ab initio. That's the order of this court. Now, at this point, Mr. Cook, because the court has ruled that count 1 is dismissed, the theft charge is dismissed, and because there has been an amendment to count 2 making it a minor misdemeanor, at this point you're not entitled to court-appointed representation. You understand that?
I do understand that, but I think that the facts underlying what Your Honor just ruled to are, there's some information that you're unaware of.
Well, I don't know what you could present that would change my mind.
May I?
Have at it.
Judge, on, let me get the exact date. I have sent my attorney, and I have all my emails here that I can produce, notification that I was setting him second chair.
You
Because,
didn't say that in open court to the judge.
I'm sorry,
You did not say that in open court to the judge.
I was unaware that I needed to do so, however.
Okay, that kind of ends it right there, Mr. Cook.
Okay,
So, I take it, Mr. Morford, based on the fact that Mr. Cook is not entitled to court-appointed representation, you would like to be relieved of any obligation to represent him, is that correct?
Absolutely, Your Honor.
Very well. Mr. Cook, because there's no incarceration that could be associated with the charge as it stands at this point, the court is going to allow withdrawal of representation by Mr. Morford, and we can proceed on this as a minor misdemeanor. It'll be a trial to the court unless there's a resolution.
Judge, if I may, I would prefer, if you would allow me, I have audio recordings and video recordings of Mr. Morford lying to me, hiding documentation from me, lying about the existence of documentation, violating numerous ethical rules that are set forth by the state of Ohio. I have audio recordings of phone calls that I had with him. And Mr. Morford brought up the fact that he was never given the opportunity to consent to the recordings. However, Ohio is a one-party state when it comes to recording phone conversations. So long as one party to the conversation is aware that the recording is being made, the recording is legal and lawful. In addition, Judge,
Objection, Your Honor, this is completely irrelevant.
Mr. Cook, what's this have to do with the charge against you?
it has to do with why Mr. Morford is being relieved, Judge.
No, he's being relieved because the charge against you now is a minor misdemeanor. It carries with it a penalty of up to $150 in court costs. Now, how you deal with that is going to be up to you. You may hire your own attorney, retain your own attorney if that's what you wish to do. But this court has allowed Mr. Morford to withdraw, and in fact, there's no basis for him to be your attorney in this matter at this point because there's no incarceration that could possibly come about if you are convicted of the charge of disorderly conduct.
Okay.
Do you understand that?
I do.
Okay. Mr. Morford, you are excused if you wish to be.
Thank you. I'm going to move to the gallery, Your Honor.
Very well.
Thank you.
Now, with the new charge,
Your Honor, if I may, before you proceed, may I request any and all documents that were produced by Mr. Morford, any evidence that's in his possession, such as videos, any of that be sent to me so that I can have a full account of what he has, because there's documentation that he has not sent to me.
Judge, for the record, I've provided Mr. Cook with everything that I've received from the state of Ohio in response to discovery answers.
and that's pursuant to Criminal Rule 16?
Yes, Your Honor.
Okay.
Except, Judge, the fact is that he has made filings in this case, specifically answers to motions that I had presented, that I have not been privy to.
Judge, if he wants to give me a written demand, set forth what he is asking for, I'll be happy to try to comply with that if it's appropriate.
That's fine. Technically, Mr. Morford's no longer on the case. You have whatever information he has that he can provide to you, he's indicated he will provide. So I don't see any prejudice to you at this point.
Okay.
All right? So,
Judge, one other issue I'd like to bring up momentarily. Are you aware that there's at least one fact witness in the courtroom at this time as a member of the court?
and what's the relevance of that, Mr. Cook?
Well, I think that in the concept of a fair trial under the Eighth Amendment, Judge, persons who are,
Under the Eighth Amendment?
I'm sorry.
You're not an attorney, are you, Mr. Cook?
No, Judge, but
Okay. Look, we'll be happy to give you a trial in this matter, a fair trial. I don't know what additional information, or it's not even information, but what discovery you need to try this case. But that's something that the court is, Mr. Ashworth, have you provided all discovery in this matter, is that correct?
Your Honor, actually, before I was assigned to this case, discovery was had between the state and the defendant in its entirety. And there's been nothing new that he doesn't have. However, I will represent to the court that I will go through and vet anything that he doesn't have, and he can have it. I have nothing that I'm going to keep back from him.
I need a copy of the video surveillance, Judge.
I don't have that. And if I don't have it, then I can't make it appear for him. So that's a different issue.
I know Mr. Morford's in possession of that video surveillance, Judge.
I'm sorry?
I know that Mr. Morford is in fact in possession of that video surveillance.
Then I would demand it then.
All right. Well, at this point, are there any motions that you're going to wish to file? Or first of all, are you going to retain an attorney to represent you in this matter, Mr. Cook?
I have not yet decided, Judge, but I am going to request...
Well, we need to decide that, because you're either going to represent yourself, that is, you're going to be a pro se defendant, or you're going to retain your own counsel who will serve as your representative. It's either or here.
I'm aware of that, Judge, but given the fact that this was just dropped on me 5 minutes ago, I would request from the court maybe a day or two to make a decision on how I want to proceed. In addition, Judge, I believe that there are fruitful conversations that can take place between myself and the prosecuting attorney once he actually receives the video surveillance.
I'm more than willing to have, I actually tried to introduce myself to him earlier today and he wouldn't shake my hand.
Okay.
But it doesn't hurt my feelings. I'll be happy to work with him through anything that he wants to work through. I am not, sir, I'm a special prosecutor. I am not the prosecuting attorney's office. And I don't have any vested interest in you winning or losing your case, just making sure that it's appropriately set forth before the court. That's all I care about.
Well, and I'll say that I respect that position. The reason that I refuse to shake his hand, and I want the court to hear this, is because of the filings that he made yesterday, okay? He made these filings without having all the information, specifically the video surveillance in hand. The video surveillance, I believe, will dramatically impact his filings, especially his special project fund. Not only that...
I'm taking that under advisement. I don't know that this court, or at least I, as a visiting judge here, have any authority to set up a special project fund for this case, I don't know that it could be done retroactively if it were set up. So I don't know. I'm taking that matter under advisement. If you want to file something in response to his motion, feel free to do so.
Well, and the other thing I'd like to bring up, Judge, is the other motion he made yesterday, the special statement, that was made in the 11th hour. I just received it yesterday. It was just filed. I haven't had a chance to fully review and look through the law as that statement.
Well,
Oh, I'm sorry, you're talking about the special project fund, sir?
No, the special statement,
your position statement.
position statement, that's the one.
That's settled law, Your Honor. I appreciate what he's saying. I would, honestly, the fact that I submitted it early was a courtesy. I was just bring it up in court today and make the same movements here. So I gave you an extra day.
Well, and
But it's settled law. Feel free to review it. I'm not trying to hide the ball here.
one thing I'm trying to convey to the court and to Mr. Ashworth is once he actually views the video surveillance, that may severely impact his.
No, it won't, Mr. Cook, and
Okay.
I'll tell you why. What you did by making those filings while represented by Mr. Morford violates Ohio law. It's not a criminal offense, but you're not entitled to hybrid representation in the state of Ohio. In fact, I don't think you are under the U.S. Supreme Court rulings entitled to hybrid representation. You may represent yourself and maybe have an attorney who is sitting to advise you but not representing you. Or you can have an attorney represent you. But you can't combine the two where you're filing documents while you're represented, okay, without the approval of your attorney. So you may not appreciate it, you may not like it, but that's the law. And that this court's going to follow the law.
Well, Judge, if I may, given the fact that those filings were not accepted, I'd like to resubmit them at this time for consideration.
Resubmit which ones?
All of the filings all of the discovery requests that I made, and I'm going to have an additional discovery request, Judge.
Look, on August 27th, you filed a letter of intent to sue. You want to refile that?
I didn't file that, Judge,
It's signed by you.
but it was not filed by me, Judge. That was emailed to Mr. Morford, not for filing, for his own information,
Well, it got filed. so-
without my instruction, without my request. And I had the email.
Why don't you decide what filings you want to make
Mhm.
that are relevant to the case as it's now existing? It's existing as a minor misdemeanor, disorderly conduct.
I'm aware of that. And this case bumps right up against the First Amendment's protection of free speech and right to redress grievances with your government.
Well, I disagree. By the way, Your Honor, everything that he's filed up to this point is void. It's not, he can't resubmit it because it was submitted improperly to begin with. He has to recreate it and file it appropriately under the rules. It has to be a new filing, signed by him, while Mr. Morford is no longer counsel of record. And that's what I'd ask that he do appropriately.
Then I request leave to do that, maybe 48 hours to resubmit those filings.
You can have weeks, Your Honor. There's no timeline for
There's
it.
no timeline on this. I do want to get this matter resolved for everybody.
So do I, Judge.
Okay. And I don't know what to tell you. I'm not going to give you legal advice, but the advice I am going to give you is that anything you want filed now, you're going to have to recreate and submit. I want you to submit it either by, do you take email filings here?
If we can, but not criminal matters.
Not criminal matters, so you'll have to mail those in. I have concerns only because of representations that have been made to the court regarding things that have occurred here. And I don't want to have any other incidents or alleged incidents happening.
Judge, I can offer this court a third option.
What's that?
The last 2 times that I was here to file documents, I audio and video recorded those filings, okay? It captures the entire conversation. Through that conversation, I was perfectly polite and courteous with the clerk staff. I will offer that if I have to come here to make filings, I will audio and video record those with my phone, okay?
Objection, Your Honor, that doesn't protect the people here that I'm trying to help.
No, but-
That are scared and worried. That doesn't-
Let's make your filings via mail. You can do it via mail, via FedEx, UPS. You can do it some way other than appearing in person, because I know the staff here feels uncomfortable with you being in person, unaccompanied. So let's do it that way.
Then what if one of the bailiffs escorts me to the clerk's office?
Mr. Ashworth, what's your position on that?
Well, I certainly don't profess to understand the logistics of the staffing here, but my understanding is sometimes that's not available, Your Honor.
I can make a phone call and prearrange to come in and make the filings.
I would have to talk to the victims before I could commit to that, Your Honor, because some of these people are really, truly worried and scared.
Okay, then what we'll do, let's see if we can get a way to allow you to file things. Certainly, you can always file them by mail, or UPS, or FedEx, or some delivery that way. It's not, I'm speaking.
My
Why don't you
apologies.
let me speak?
My apologies.
Please. And we'll do it that way unless we can come up with a different scenario for it, because I want everyone safe. I want everyone to feel safe and feel secure here at the courthouse. And that includes you, okay?
May I say something?
Yeah.
Judge, I want the same thing. I want everybody to feel safe. Spent 9.5 years in the Army and deployed numerous times to Afghanistan to defend this. I don't want anybody to feel unsafe at all for any reason. And I have no intention, nor have I, done anything, and this will be reflected with the surveillance video, to cause anybody any kind of fear.
Well,
And
I think there's some people here who might disagree with that, and I don't want, I don't want to cause any more issues than already may exist. So, and there may be no issue here, I don't know. You stand right there as a citizen accused of disorderly conduct. You may want to speak to Mr. Ashworth about a resolution here. I don't know if that's possible. If not, we'll set this matter for trial. Within the next 10 days, if you could file any requests for discovery, and it has to be in accordance with Criminal Rule 16. I'm going to hold you to those rules if you're representing yourself, or if you retain an attorney, then the attorney can do it on your behalf, okay?
I'm going to let the court know that I'm going to reach out to the Southeast Ohio Legal Center, which does pro se representation for indigent persons, which I fall in that category. I also have some other avenues that I'm going to explore. However, in good faith, Judge, I'm going to submit these motions for discovery within, today's Thursday, so hopefully no later than Monday. Okay? However, I do ask that if the court is going to require me to mail them, that the court offer a little bit of a buffer there, because nobody can control the mail.
Well, I'm fully aware of that. I'll tell you what, can you get it in by November 17th, any of your motions?
I don't see a reason why not, Judge.
Okay, let's make it, unless you have retained an attorney to represent you, that you'll file any motions that are pursuant to the criminal rules. I said discovery is Rule 16. That's only one of a whole bunch of rules. So let's let's do that, get that filed no later than November 17th, all right?
That's fine, Judge.
Is there anything further we can do here today, Mr. Ashworth?
To the extent we can, I would somewhat prefer to go ahead and set the trial date, but that's completely at the discretion of the court. If we haven't addressed that, I assume we don't want to broach that yet. So that would be the only thing I would have.
Is there, assuming that you can respond to the discovery and we don't have a problem, can we set this for trial maybe December 15th? Is that, are Mondays good, or what's a good
Mondays are
day?
not good.
Okay, what's a good day that week?
I would say a Wednesday or a Thursday.
How about Wednesday, December 17th? Does that work?
That should be fine.
May I have a moment, Your Honor?
I don't have anything on that day.
Okay. I should look and see if I have anything. It's not going to be a trial without me.
Your Honor, on behalf of the state, that date's fine with me.
Okay, let's make it December 17th. Let's do it at 11 o'clock.
Your Honor, on the deadline for the defendant, is that to file any motions for discovery?
Any motions or motions for discovery? Yeah, any type of motion.
I would like the right, Your Honor, to have that same opportunity, because it sounds like they've got some things that I don't have.
Okay, that'll be fine. We both have that.
And that was at 11 o'clock, Judge?
11 o'clock, yes. All right, if there's nothing further, I am taking that motion. If you'd like to respond to the motion, Mr. Cook, that Mr. Ashworth filed regarding the motion for designating a case-specific special project under revised code 1901.26B1, you may do so.
I would like to discuss that, Judge. And I haven't...
Why don't you file a response rather than, unless you want to argue it orally, Mr. Ashworth?
I think it would be most appropriate for the defendant to have an opportunity to review it and file some written stance on it, at which time I will take his research under advisement and then tell the court whether I'm going to continue to pursue it, potentially withdraw it, or ask for oral argument on it.
Okay, why don't you do that by the 17th?
I can. If I do have a couple of issues that I'd like to bring up now, if it's okay, because it relies on his special project fund relies on a couple of assumptions that he's made without having all the evidence, and I can take less than a minute to address the issues that I have.
Well, look, I know what I've read his motion, that what I have more of a concern about is don't worry about the factual background. Worry more about whether under the Ohio Revised Code and under any case law that I, as a visiting judge, or such a fund could be applied retroactively in this case.
There's one factual thing that he's not aware of that I'd like to make him aware of, that this relies on.
What is that?
It relies on the fact that I made the motion to disqualify the prosecutor's office. Okay? The fact of the matter is, if he takes the time to review the hearings where that motion was made, Mr. Heald was the originator of the idea for the prosecutor to recuse himself for a conflict of interest. That was not my idea. That was an idea initially proffered by Mr. Philip Heald, who was, in fact, the prosecutor at that time. I only brought it up in court because nobody else did.
I'm I'm going to caution the defendant, Your Honor, if he continues to discuss these conversations between him and his prior counsel, I'm going to ask the court to lift the privilege and let me interview prior defense counsel.
Mr. Cook?
I'm just discussing things that were discussed in open court. This was all discussed in open court, Judge. None of this is privileged.
Well, okay, none of it that is privileged between you and Mr. Morford, the court is going to allow you, Mr. Ashworth, to speak with him regarding disqualification, or it's not the disqualification, but the request to have a special prosecutor here, okay?
Judge, that was all done on the record, and I don't know what additionally my attorney could proffer because everything was brought before the court.
All right. I think you should allow, though, Mr. Ashworth, the opportunity to make certain that that was everyone's understanding, all right?
That's fine.
Okay. Is there anything further we can do here? I hear nothing, then we are adjourned.
Thank you, Your Honor.